Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case.
Am I legally responsible if my spouse signs a contract without telling me?
In regards to contracts signed whenever you're married and one spouse signs a contract, the other person doesn't sign the contract, it really depends upon with either what entity or person that you're signing the contract. If you're signing the contract for tax purposes for the IRS, you may very well be liable, but it depends upon whether you're able to assert the innocent spouse provision later on down the road. However, if there's a contract signed with, let's say, purchasing a car or purchasing a home or possibly even a contract for some sort of other credit, if you did not personally sign that, generally, for the matter speaking, those creditors cannot come after you personally. Now, the court could order that you guys share jointly and severally liable for those debts. And if that does occur, the credit card company still can't come after you. But if they go after your former spouse once you're divorced, and that former spouse has to pay, and you were supposed to pay 25, 30, 50%, then that spouse can come back and sue you on the divorce decree, which in itself is a contract. You agree with that?
Correct. And then when they come back and sue for those payments, then they'll get a judgment, and that judgment would have to be paid out. But the creditor cannot directly come after somebody that they did not directly contract with for those debts.
Does the same rules apply if a contract was signed prior to them being married, but now they're getting divorced? Is the spouse held liable to contracts that were signed prior to marriage?
Any contracts that were signed prior to marriage are what I believe just like separate property would be, meaning if you had acquired an asset prior to marriage, with you being able to prove that it was separate property, would be your separate property. Just like a debt, if one spouse had signed a contract prior to marriage and they were trying to state that the other spouse was actually liable for it, the spouse that is asserting they're not liable could go back and say, actually, you signed that prior to marriage. Therefore, that is your separate and sole liability and has nothing to do with our community estate.
Agreed. I think the only time we see anything different, and what we always worry sometimes, is people will purchase a home in one person's name prior to marriage. And then at some point during the marriage, they decide to refinance it, and then they'll refinance it into both parties' names. So there is a change there about liability. So do make sure that you pay attention that if you've got something that's in one name only and you do something with it during the marriage, whether you make the determination of whether you intend for it to be both of you or just continue to be separate.
Yeah, that could change the characteristic of whether or not that asset or debt is separate or joint, meaning separate property or community liability.
And so how do credit cards kind of come into play when you're going through divorce? If it's only in one name, does it go to only that person? If you're joint on that credit card, how does that all work through a divorce?
Well, credit cards are much like what we had discussed in our previous question about debts and whether or not if somebody signed solely for a debt or they were joint for a debt. If both of you acquire credit in both of your names, that creditor can come after both individuals, meaning they could try to settle it in full with just one of the parties or settle it in full with the other party, or they could also try to come after both parties if they wanted to. If you're just simply a signer on a credit card, again, whoever has actually signed the contract with the creditor, that's who's going to be solely liable. But if the court were to take a credit card, regardless if it's joint or severally liable, if the judge decides, or maybe there's an agreement that was entered with the court and it's in your decree that both of you were going to split that card, if one party has to pay more than the other, then that party could go sue on the contract, which is the divorce decree, and enforce and request the court to establish a judgment against the other spouse and request that they pay that.
Absolutely. It's exactly the same.
So I guess a judge would step in too. Let's say if we took a business loan out, well, we took that business loan out with the intentions of being able to pay for our house, our groceries, our mortgage. How will that business loan come into effect if it was only in one spouse's name?
So if there are any loans that are taken in one spouse's name, the creditors are only able to come after that particular spouse. Or if there is a business that you have, and let's say that the spouse used the business to acquire the debt or the loan, it would also depend upon the creditor could also come in, and if both spouses said they're not liable for the debt, the creditor could come in and actually do what's called pierce the corporate veil and come in and say you were basically living vicariously through that business. And if you took those funds, you used it to pay community debts, etc., they could come after the individual that signed the contract, but they can't come after the spouse that never signed the contract. However, again, if a judge or there was an agreement for a decree that was signed and entered with the court that somehow established a separate way that the debts were going to be paid, then either spouse could sue the other spouse if they have to satisfy in full or in part more than what they were ordered to do in regards to the debt.
Mm-hmm.
You agree?
Yes.
How are medical bills kind of falling through with divorce? Is it all the person that got the medical kind of care at that time responsible for all of that? Or can medical bills be put into your divorce?
Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to Behind the Case.
You can put them in by agreement, but again, it's really kind of no different than a creditor from any other part of your life. If it's your medical bill, you were the person that received the services, you contracted for those services, you were the person that most likely signed as being financially responsible for those services, you're going to be responsible for paying that debt. But if there is an agreement, because parties can reach agreements to all kinds of things that a judge would not necessarily order, then that can be put in. But again, if a party fails to pay something that was not in their name, then the only recourse for the other party is to take a civil suit against them and to seek a judgment.
How do the courts handle contracts or secret loans that come up in divorce? So let's say they signed a contract in secrecy that doesn't come up till the divorce. How does that affect it?
Well, anytime that there's any type of contract, whether it's a debt or an asset, if something was hidden from the other party, most of the time the courts will kind of come down on the person that was doing the hiding, because that's what's called a breach of your fiduciary duty. You need to make sure that in your petition for divorce that your attorney understands how those types of theories work, and that you make sure that you put in your petition for divorce that you're requesting a breach of fiduciary duty, sometimes a reconstitution of the estate, etc. And generally speaking, when that occurs, the courts take into consideration the ill will or malicious intent that the party who is, I would call the wrongdoer, they can then assess against them different types of penalties, even sanctions. But most of the time, it's how they're going to divide the actual estate, whether it be for liabilities or assets.
Right. There can be a disproportionate division based upon the judge's interpretation of why that person was hiding something. So it can definitely be a factor.
Can prenuptial agreements protect you from these kind of contracts or liabilities for debt?
Yeah, premarital agreements are entered into, for the most part, to basically to agree as to what is separate property, what is community property, and whether or not there's even going to be community property or debts established throughout the marriage. In a premarital agreement, you can make all sorts of agreements, so long as it's not against public policy, as to how your estate is to be divided. When you acquire certain assets or debts, how it's going to be characterized, how things are going to be split if and when there's a divorce. You can have just about anything in a premarital agreement that you want to protect yourself and or both parties from malicious intent, breach of fiduciary duty, and also to almost prevent the family court from having the ability to even divide community assets if your premarital agreement is done properly.
Yes, but it has to be done properly and meet all the requirements of a valid premarital agreement so that the court doesn't have the opportunity to order that it's unconscionable or that it's invalid or anything of that nature. But it is absolutely the best way to protect from any future financial activities from either party.
What steps can a couple take to separate their finances legally during the marriage?
Well, I mean, one of the best ways to do it is what's called a partition exchange agreement. A lot of people call them post-marital agreements, but really the best way to characterize it is a partition exchange agreement. You can also do that if you're in a mediation, you're trying to make a statement of, hey, I have a business and it's worth X amount of dollars, and I'm going to pay this person to pay him out over 10 years, and I'm going to establish some sort of loan. You're really creating something that doesn't exist. It's a weird concept, but courts really should not recognize that is some sort of a debt. That was something that doesn't really have a bargain for exchange. It wasn't a debt that was acquired as a community asset. So in a partition and exchange agreement, you can put whatever you want to in there about how you're going to partition exchange your community assets and debts. You can even create other debts that would be included in that partition exchange, which would give yourself a bargain for exchange, which would allow the contract, which would be the partition exchange agreement, for it to actually be valid.
Mm-hmm. Absolutely.
Somebody that is about to go into a divorce who has a lot of contracts, they want to make sure that are being handled correctly. How do they reach out to your firm, and what is that first step?
So if you have issues, whether it be business or you have a trust or you have just financial assets and or debts that you're unsure of what you need to do with those, you're going to get divorced, either your divorce has started or you're in the process of getting a divorce started, you want to make sure that you reach out to attorneys who understand all the different legal theories and the family code and how those things are applicable in the real world. At our firm here at Turner Monahan, we have numerous experienced attorneys who understand how these things work and how these things are applied in court. And the easiest way to get in touch with us is go to our website at tumolaw.com, or you can call our office phone at 817-332-4477.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com. That's TUMOLAW.com, or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.